Laughter, okay. Laughter, happiness, and constitutional law. In these times of tears and rage, we need to have a break and think about laughter and happiness. I must confess, this is my third contact with the topic. 10 years ago or something, I was request from my friend Rainer Arnold, that was visiting the law faculty of Lisbon with other constitutionalist colleagues from Southern Korea, to organize a conference on a topic chosen by the Asian colleagues on happiness and the law. I was the moderator of the session, and I must confess that I discovered that it's possible to look at the question of happiness from a constitutional law point of view. But more closer to that, during pandemic 2020, I had a challenge from a Brazilian colleague from Fortaleza, Professor Humberto Cunha Filho, who challenged me to talk about laughter and law. I might say I have an affectionate relationship with University of Fortaleza and its group of studies and research into cultural rights, and I think it was a good experience, but I didn't progress much to the first time. So I thought it was an unusual theme. I accepted the challenge, and in a kind of intimate tone, I made a talk between friends. Now I was invited by Dimitris Parashou, our Greek colleague from Hanover, to do the inaugural lecture of the series, Transcontinental series, and I didn't know what to talk about. I was tired of seeing the images of war, fire, and rage on the TVs, and I reminded to take seriously at the first time we say in Portuguese is the decisive one, the third is the decisive one, and I decided to talk a little bit seriously about this never-ending topic. I start with a kind of declaration of interest. My view of constitutional law is very much influenced by my idea of culture. And I can say that I consider constitutional law as a kind of science of culture, as Haberler says. On another perspective, there is a group of law philosophy that I like very much, the rationalist or postmodernist theory of law, with a group of American professors, Boyd, White, Belkin, and some German too, that try to approach culture and law, bringing law closer to literature, to music, to performing arts. And in my view, that's a good way of doing the things. And that's a good way of talking about laughter and the law. I begin with an experience that I had some days ago. My last concert 2 weeks ago in the Gulbenkian Foundation. It was romantic music, Romeo and Juliet from Berlioz. And I thought that I could use this example of a music show in order to do a kind of comparison, like Balkan does, with the music and the law. First, we have to say that both law and music are derived from a paper, from a written paper. There is what we can call the law in the books and the music in a paper. And what each member of the orchestra does is to create that music, turning it into music. And that is exactly the same that does a group of parts in a courtroom. Let us say that we did by a judge. There is moderating the session and also producing another interpretation of the law. Let us say that the judge has a similar position as a régisseur, as a chief of the orchestra. It tries that each musician enters in the right time. As a matter of fact, it's not necessary to have the chief of orchestra. In the Baroque times, there was not. Now, after the Romantic tradition, they become normal, and they are those who unify, who make that all the musics that create with his own instruments will be there at the right time, enter in the right time. And that's exactly what happens also in a court. There are two or more different views of the law, a view of the active subject, a view of the one that is the defendant, and even in a team, there can be some different views, and there is the judges who try to coordinate that individual work of creation and also contribute to the idea of the creation. And that is done in a room, in a house of spectacles, a theater, like in the Gulbenkian Foundation, or in a courtroom. And people there is in the room as a reaction to what he heard in the court and in the room. And that reaction can be patriotical, like it was in the Gulbenkian Foundation. It was a very good night. The musicians were inspired. The music was too romantic. And in the end, it was indeed une petite apothéose, as we say in this kind of shows. But it could be a disaster. And in the end, the public could not say nothing or being angry, sometimes even throwing something to the artists and these kind of things. In the courtroom is the same. After the emission of the decision, people in the room react. Sometimes they agree with the decision, sometimes they don't. And there's also an echo from what happened there in the society. There was a critic in my newspaper the next day talking about the wonderful concert. There are news, and there's the result, the social result of the courtroom that we attend, visiting the society, reading law books, reading jurisprudence decisions, and so on and so on. So the two phenomena are two phenomena of creation. Creation, the law in the books, in law in action. That creation is different and has its basis on a subjective point of view. The interpretation is something that is not unique. The positivists used to say in the 19th century, there is only one interpretation of the law. That could be no more wrong. It's difficult to find another affirmation so wrong. Look, in my course, I have a view that is not the same as my assistants have. And I can say that we are six. Well, my view is the one I teach, the one that students should learn. But it's good that they can also learn from the views of my assistants. And I know that they think different, and I think that's great for the students to understand the idea of a community of judges, a community of persons, community of interpreters of the law, that from a text and from a subjective perspective try to come to an objective result. And I use this kind of cooperation and kind of comparison with my students in order they can understand that what happens in a court could be different in a court deciding the same question, the same topics. And that's why we have a system in order to try to give to everybody the chance of having a second opinion, a system that allows to put in question the first decision. And we could go on eternally with that, but we cannot, because for reasons of security, there is a moment that we need to stop the discussion, and that when there is the power of decision, the power of la chose jugée, as the French word says. So it's very important to have this kind of approach in order to be able to understand how things are. Hello, Friedrich, how are you? How things are. And from my point of view, that's a very good way of introducing these questions of law and culture. But I have much more experience like this with my students. I tried the psychoanalysis for administrative law, the cinema for explaining environmental law, constitutional law, gastronomy for teaching the discretionary power. And there's nothing better than a cookbook in order to show the students what is mandatory, what is discretionary, what is salt and pepper according to your taste. Too much pepper is against the law, will destroy the recipe. Too less pepper can also destroy the recipe. What is in the middle is something that you have to decide, and the result can be a little bit different from one cook for another, and with the salt exactly the same. So it's a wonderful way of explaining the idea of discretionality to use this kind of comparisons. And I added some more even recently in a text that I written to a book published in Germany by Bernd Oppermann, Professor Oppermann, that is here present. I also used to talk about tech law. I also use media sociology, probability and statistics, and neuroscience, because I thought it was a good way to understand the new phenomena of tech law. So, from my point of view, law can only gain from opening up to the cultural dimension. And the cultural discourse should integrate culture and integrate law, because law and culture have a kind of love relationship, and this love is good, is benefit for all the partners. But in this vision of law and culture, I would start to do a kind of superego analysis using psychoanalysis, using some stereotypes of laughter and seriousness in law and culture. Apparently, there is no relationship between them. Law is so serious that its image the very image of justice, is a blind goddess. More serious it could not be. And that gives an image of the law that is seriousness, severity, impartiality, guarantee of public interest, and legal order. That have lots of consequences in politics and law. Politicians and lawyers don't usually laugh. They don't cultivate the sense of humor. Of course, there are exceptions. But what they do, according to our superego, is to be serious, respectable, and try to behave like that. And the thing is even worse when you talk about revolutionaries, because saving the world is a serious task. Just look at the pictures of Marx, Lenin, Stalin, and Mao Zedong all together in a poster. I think it's something that scares any little child because they are so serious, showing they don't play during the revolution. And radical environmentalists that we are having now, let me say, I'm an environmentalist. It's a good thing, but to be a radical environmentalist is not a good thing. Let's look at Greta Thunberg at the United Nations, pointing out everybody and say, you have destroyed our lives, crying in a angry way to the other guys that suffer as she the problems of over-industrialization, of not taking care of the environment and these kind of things. And now you are assisting. Yesterday was in Portugal a group of environment radical activists that throwed ink to the Minister of the Environment. There was talking about how to protect the environment. And then others that went to the Berardo Museum and attacked the only Picasso that is there, saying the world is going to die, so we don't need art. They don't need art, and they also don't need to laugh. They don't know how to laugh. They are too serious in their radical fight against something that they think it's not the right one, and they are true. But the way they do it is not the correct. So lawyers don't usually laugh. From court rooms to war rooms in our faculties, in our auditoriums, it's rare to see someone laughing. On the other hand, from the point of view of the superego, laughter can be the subversion, the madness, the excess, the abnormality. And I take two examples from the movies, from cinema, that I like very much. We have the contrast between being serious and laughable in Charlie Chaplin films. The Policeman and the Clown, The Defender of the Order and the Vagabond, the serious against the poet. Or another example are the Fellini films, The Love of the Clown, The Circus, The Deviance of Life, those who laugh. And yet, laughter, it's a very serious thing. To end this kind of considerations, cultural considerations, I'm going to give the example of a book I loved from Umberto Eco, that is The Name of the Rose. That gave a good film. I don't say a magnificent film, because I didn't like so much some unnecessary grotesque side, but I loved the magnificent interpretation of Sean Connery, and I think it's a good way of showing in cinematic language the wonderful book written by Umberto Eco. And The Name of the Rose, it's a detective story that happens in a Benedictine monastery committed by a blind monk, guardian of the monastery's library, where ancient classics were translated into more modern language. The name of the monk was Jorge de Burgos, which is the alter ego of Jorge Luis Borges, a poet blind that has a wonderful library. By the way, like Umberto Eco too, there's now a film in Portugal about the library of Umberto Eco. And Burgos poisoned the pages of Aristotle's book on laughter to prevent the other monks from reading it and to expand something that could be danger, laughter, the dangerous thing of old times. So there is lost Aristotle's book that makes the apology of laughing, that is the center of the whole plot, and justifies all the crimes committed in the abbey. So we have to conclude that laughing is really a serious business that can determine life and death. Let me go now to some political constitutional aspects, some legal constitutional aspects. Happiness as a constitutional principle and a fundamental right comes from the American constitutionalism. The idea of pursuit of happiness is something that comes from the Declaration of Independence and is part of the material Constitution of the United States. And I should say that until now, the Americans, with some other exceptions, strangely enough, also the French, as we'll see afterwards, and the South Koreans. That's why my colleagues from Asia, the friends from Rainer Arnold, wanted me to have a conference on happiness. And when I discovered this team 10 years ago. And in the Declaration of Independence, it is said in a historical way, a little bit naive, but that represents the spirit of the time. They say, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So the pursuit of happiness becomes not just a goal for political power, but also as a kind of human right, and is viewed in this double dimension in the American Constitution until today, because that liberal point of view was not changed with the amendments that were introduced afterwards. And we can say that the problem of the American Constitution is there is an American Constitution that still lives in the liberalist times in the 18th and the 19th century. But there was something I discovered afterwards, because I never paid attention before. It was that during the French Revolution, the French revolutionaries always speak the idea of happiness. And I discovered that Robespierre, who else, was responsible for the introduction of the idea of public happiness or general happiness. And I've seen a very interesting article from a colleague, a historian colleague of France, Félicien Lemaire, that deals with this question of le bonheur comme principe constitutionnel. The idea that there is a constitutional principle on happiness. And I was, for one end, surprised, because I knew that idea from the American system. But then I look back, and I've seen that the French constitutionalism from the liberal times, influenced by the American one, also in the Declaration of Human Rights and Citizen, that integrates nowadays the preamble of the French Constitution of 24th July 1973, speaks of bonheur de tous, the idea of collective happiness. And they see happiness as a collective good, more social and more collective than individual, but also a task, a goal for the Constitution. And I believe that stayed in the French Constitution because the French Constitution is not a Cartesian, rationalist, positivist, as we could think it would be a constitution coming from France. On the other hand, is a constitution that deals with the political power and some intervention in the society, even that very small, and does not deal directly with human rights. They make a construction to integrate the human rights in all the other constitutions from 789 in the material constitution. And it's very funny to see that the French constitutionalists, there are almost all of them. There are good exceptions, and they are my friends. But almost of them are positivists in a very strict way. At the same time, they defend the idea of a material constitution in order to integrate the fundamental rights that are not dealt in the Constitution. And nowadays, they even had to find a charter for the environment because the environment was not dealt in the Declaration of the Citizens. It was not a problem then. It's a problem now. So they made a kind of amendment in the American way in a charter, also with material constitutional force. There is part of the formal constitution, although it's just material in a sense that it's a formal law, not a formal constitution. So looking at this, and from a legal point of view, I think we could say that there are two different views of looking at the happiness as a constitutional value. There is the idea that this constitutional value is mainly a fundamental right. There is the idea of the American Constitution. There's the American way of seeing the thing. And we can say that it's mainly a constitutional task, something that is created for the good of the people, and that we can say it is the French way of seeing these things. Taking this discussion for today, I think we may agree on two things. First, that the pursuit of happiness is undeniable a constitutional task, whether it is directly in the Constitution or just indirectly with the enshrining of the other rights, fundamental rights and liberties. And that means that happiness requires objective measures to achieve it, even if it is an expression that gives to political powers great discretion to implement it. If you think about the idea of a human or fundamental right, I think it's more difficult to admit the idea of a liberty that requires omissions of the public powers, and it's difficult in such an open and vague concept like it is the concept of happiness, thinking about this idea of omissions of the state powers. Either we include everything, either we don't have nothing to include in the concept. And the idea of right that requires specific actions that are done by the public powers because they are a duty of the public power and a subjective right of the citizen. This is also difficult to find because these duties are not specified enough. However, we may say that the pursuit of happiness is a guarantee given from the state to the citizens to preserve their fundamental rights. So it may have a subjective dimension, not just the objective one. So the guarantee of happiness may be considered as an element of the content of human and or fundamental rights, like the term we use in Portugal, in the Portuguese Constitution, which speaks of rights, freedoms, and guarantees to refer to the first generation rights, the rights coming from the liberal constitutions. And in that sense, we are able to integrate in the concept of fundamental law also something there has a more objective component than the liberties and the rights. And I think that that's an idea that has been defended in constitutional law by a dear friend of mine, a German friend of mine, Hartmut Bauer, a colleague from the times we were both doing our PhDs in Augsburg, a small and bucolic town in Bayern. We sat very close in the library. We used to talk about what we were doing in our thesis with my wife too, that was also doing the PhD at the same time. We have very good conversations, and we keep discussing and quoting each other nowadays. And Bauer says that, and I agree with him in that more important than the idea of right is the idea of relationship, and the constitutional relationship as a complex power integrated by different rights, by duties, by guarantees, by duties of the privates, and there is a kind of mixed combination that is the constitutional relationship. And we still have a kind of discussion because it says that constitutional law should do like administrative law did already, and in that we will agree, and enlarge the fundamental rights also to positive rights, not just the omissions, and it's a minority position in the German doctrine. But taking this common opinion forward, I think we should now, we had, as Bauer explains, the transit from the constitutional law, from the fundamental rights, to the enlargement of the administrative rights, subjective rights. Now we need to do, my opinion and my discussion with Hartmut, we must do the reverse way and enlarge the fundamental rights, those that are in the Constitution, with the example of the rights of administrative law. because we have no problems in administrative law to say that a positive action, that a duty of the state is a right of the people, and the constitutionalists, not all of them are able to say it. And that's not just a German power problem. It happens in my country too. So, looking at the present situation, and according to this constitutional tradition, both in America and France, we are able to consider that liberal constitutionalism directly protected the happiness. And that was generalized in many of the liberal constitutions in Europe and America at the time, in Spain, the Cadiz Constitution, in Italy, also in the times of the liberalism. But afterwards, with the social state in the beginning of the 20s, with the exception of the EU, France, South Korea, and some few others like Brazil that tried to have this kind of idea of happiness in an amendment that I think it was not approved, but I'm not sure if it was afterwards. I couldn't find, I didn't have time to look for literature. If afterwards, after the first rejection, it became to be effectively turned into law. I can I can suspect that probably that something like that happened, or at least an adoption of the doctrine of this idea, because I was able to find in a lot of colleagues from Brazil this idea of happiness connected with constitutional law. So, in conclusion, we can say that the social constitutionalism and now the post-social constitutionalism that we are living in does not directly protect the pursuit of happiness, but indirectly, with the consecration of fundamental rights, not just of the first generation, but of the second generation, on the economy, on society, on culture, and those of the third generation, like the environment, like in the field of digitalization, like in the protection of the essence of life in neurosciences and other things like that. Indirectly, those human rights basically introduce this idea of protection of happiness. And as a matter of fact, happiness is required both with regard to fundamental rights and to the organization of political power, like in the liberal constitution, for the rule of law, for the separation of powers and the protection of minorities. It's a guarantee of laughter in society. When we look at authoritarian societies, nobody laughs, and those who dare to laugh finish in the prison or something worse. We find happiness in the political fundamental rights and economical, social, and cultural rights, and in other constitutions like the German one, the Portuguese one, the Spanish one, the Italian one, we also see the enshrinement of the social state, and we may say that the principle of this social state is the goal of achieving the happiness between the people. So I think we can consider that indirectly this idea of pursuit of happiness had a great importance, but still now it keeps on having importance. And now, really to conclude, I remember something that Friedrich knows very well, that has been our conference, CPEC conference, that was held in Lisbon this year in the month of June, and where Professor Germelman made a wonderful lecture on energy law. The topic of the conference was the new tasks for the state that were born first with the treaties of Lisbon, then with other material constitutions, even if they are, from the formal point of view, just European regulations, but they have the power of material constitution, like, for instance, the Next Generation EU that was concretized by the PIIs in all our countries, and now needs a new kind of pacts in order to reinforce the money, but also to be able to attend the new problems arise not just by the COVID-19, but now with the two wars that we are dealing here, one in Europe, another very close to Europe. And the idea was that these new tasks, and we studied in particular defense and cybersecurity, something that is really important in times of war. That is a kind of old new task, because was one of the oldest tasks of the state, but now it regains another importance, and this importance as a European and a global dimension. The defense of Portugal is played in the European field, is played in the NATO, is played in the global laws, in the United Nations, and so on. And peace is something that we need and we are looking for with this kind of revitalization or revalorization of this old task. Then we have health, in order to protect us from the COVID-19, but we have had lots of diseases before. There is a specialist in epidemics, a doctor, a special professor in Harvard, Hobbingsbaum, that says that we have had a century of epidemics and pandemics that comes from the an episode of pandemic that happened in the beginning of the 20th century, the yellow fever, and goes until now to the COVID-19. And let's hope for the others that will come. Luke Kemp, as an investigator from Harvard, that has a center for existential risk, says that in the near future we are going to have viruses that have been kept on ice, and with the climate change will reappear again, and they were able to take care of the dinosaurs. We can be afraid that they can do the same for us. And by the way, the center calls itself the Center for Existential Risk, something that you can look at the internet. Even has a very interesting conference there is in the YouTube about these challenges that are now opening to the law, to the constitutional law. So to be healthy, it's something that also has a global dimension, national, European, global, and it's a new task for all the political powers in this kind of dimension. Then you have the combat, the fight to climate change, and that's the face of environmental right nowadays. The climate change is the worst challenge we are facing dealing with questions of environment, and we should not despair and keep on happiness in order that we can resist. And on that aspect, there is a wonderful decision of the Constitutional Court of Germany on climate change from 2021. And let's hope now from the decision of the Court of Human Rights, even if the Portuguese guys were not very well advised, but well, they won the legitimacy problem, which was the biggest one. I would like to believe that with dialogue with the German Constitutional Court, they can also win the material decision, but we don't know. Then we have here Friedrich Germelmann that talked about energy and the importance of having sustainable energy. It's important from infrastructural point of view, but it's also important for the conjunctural situation we are living in. And we must not forget that the Arab countries in the 70s, when began our post-social state, made a cartel and were able to make higher the price of energy, and are going to do it right now. And the first threat we have is the threat of energy. So it's another thing that has to do with our collective happiness. And then we have the challenge of digital, the idea of e-government, a most flexible way of dealing with the problems, and it's completely necessary for our administration to change the way of work, and it changed already. There are lots of decisions, administrative acts, they are mass-produced, and there is something that we have to live with digital, and the idea of smoothness and happiness are very important. So, love and happiness are also very important from the pedagogic point of view. And I use them quite often as a kind of pedagogic weapon to be used in the last minute when everybody's tired of listening to me. And sometimes I find former students, and the thing they normally tell me is they miss the laughter I often give in my classes or my good humor. So let's do it. Let's finish with a laugh. That's it. So now I'm open to all the questions that you want to do. You're so kind. Friedrich, please go ahead.
Thank you very much. I'm so sorry that I came in too late. I hope I didn't disturb you too much. I had a engagement, and
never disturb.
I was glad I could make it. It was a wonderful lecture. Thank you very much, and lots of insights. And I was immediately thinking of the Homeric laughter as another cultural expression. I don't know whether it exists in English. At least in German, we have this term of this constant loud laughter that apparently the gods emitted when in Homer's Odyssey and Iliad and so on, which was perceived by the people like thunder. So when we've got when we've got thunder, it's probably the Olympic gods laughing. So that's another funny picture. I was wondering, apart from that, I was wondering, since I like very much the idea that pursuit of happiness, or the guarantee of happiness, is a task for the government, is a task for the state. And I was wondering, when you connected with this human rights dimension. Would you, but possibly my question is too much informed by German doctrine. I was wondering, would you rather connect that to the fundamental right of personalities or personality rights, or rather to this very general right that we've got in Germany to pretty much do everything you like as long as it does not disturb the others? Would you rather say happiness and pursuit of happiness is connected to this personality right, or rather is it something that you are free to do within the borders of what you're allowed to do?
Well, thank you very much. It's first for the image for the idea of the gods that are roughing. I'll take good notice and I'll use it next time to add the other examples, because it is very good. Thank you very much. From the technical point of view, as you've seen, I said that to consider it as an objective task, it's easy. To as a fundamental right is more complex. And because if I look at it as a kind of liberty, which is the close to the idea of the pursuit of happiness, the things are so vague and so open that they allowed everything. On the other hand, the idea of a right, since we have no specific duty, even for me that believe that the constitutional rights can also be positive if there is a mandatory power. It's the idea of administrative law that we could use also in constitutional law. There's very difficult to find this kind of duty. So what you say makes sense, and it's something that I also have here in my paper, and I have not time to say, that we should use what is the best to deal with it. It can be the general cause of the dignity of the human person. It can be general rights, as you do quite often in German, a kind of things that you do also with environment. That is something that comes from life, health, that for the first time was connected with the freedom of enterprise because of the Kutterschiffers case. Since it's a kind of indirect protection that is integrated in the concept of human right or fundamental right, for me are the same nowadays, but that's another question, that is integrated in that concept, we should use it as it is best in order to take the best results. So I totally agree with you when you say with those two options that we could use both, and we could use other options according to the situations, because it's something that is connected in a direct way with the notion of the fundamental right, and as that it can be interpreted in a very different way, and it can be used in a very different way. The example I've made in the beginning, I don't know if you were already here, comparing the law with a room of an opera or a theater or something like that, and the example of the orchestra, where each musician creates the music that is written in a paper, giving to it a personal interpretation. And this personal interpretation is then unified by the chief of orchestra that makes that all play at the same time, which is actually exactly what happens in a courtroom with different views of the law by all the subjects and the direction of the judge that in the end also has a new interpretation. So this kind of creation is what we need for the fundamental rights. So we should try to see what is more adapt to the case that we are dealing with, and use it the best way. So that would be my answer. And that also deals for the first question that the students asked. The first, it's how to use this idea and how to apply it. If it could be a constitutional remedy. Yes, it could be. In Portugal, constitutional remedy is not the Verfassungsbeschwerde as you have in Germany. So a private person cannot address directly to the Constitutional Court. But if he initiates a quarrel in a court of law, in an administrative court, or in a judicial court, that will in the appeal will go to the Constitutional Court, and the Constitutional Court intervene in that area. And that's a good way of introducing also happiness in the interpretation of a norm. And the question, I think, we should use the best weapons we have in order to make more efficient the protection of human rights. There is the core of the Constitution, the core of the idea of law, the core of the civilization. So something that we really need in order to be active constitutional lawyers, as we try to be, with this cultural view that can change the solutions in the community of law interpreters that unifies them. So they are subjective, but they are unified with the community of the interpreters. I don't know if I if I was able to answer, Friedrich, but thank you very much for the question. So, looking at other questions, laughter is actually an important part of India's social culture, where the first laughter club was created. This should be implemented in our schools. Well, I couldn't be more in favor of that idea. So let's do it. We should try all this kind of thing. We have a colleague in our Elpis group. This is integrated in the activity of Elpis. We have a colleague from France, Marine Touillet, that in all sessions tries to do a kind of a yoga exercise in order to teach us how to breathe and then how to laugh. So it could be a good solution. And says she uses it in her lectures. Well, I didn't try, but I used to try a lot my laughs. Everybody talks about my laughs and my good humor. I don't know if it's that good as they say, but it helps. When everybody's starting to sleep, they wake up and they pay attention. So I also try to do it, not in a such a formalized way, but there's nothing better than laughing about ourselves. And when I laugh about what I was telling, I think it's the best way to do it. Things should not be too serious. Okay, more questions. Well, if not, let me thank you, all of you, for being here. It's the first session. I hope it will be the first of many good sessions, that you learn a lot from these sessions. And I have to have a special word to my dear colleagues, Bernd Opperman and Friedrich Germelmann, that have been here listening to me, have the patience of listening to me. And well, that's something, a joy in meeting, well, like it's a joy meeting normally as we do lots of times during the year by Zoom, in person. We try to be update with what happens with the others. And this is one of the best things of this Elpis group that was created by Hanover, and that unites us all together still now, almost 50 years about this foundation. So it's something that it's really important. And by the way, let me make an announcement of the next volume, the 7th volume of our VOA review that you find in the Elpis page and in YouTube. It will be on artificial intelligence. And according to the offers I had now, I think this time it will be real global, because from the Sui Juris Association of North America, I got 3 or 4 acceptations, not yet the texts, not yet the articles, but 2 or 3 acceptations of the invitation, and I hope they work. So let's see. We never know until we see the result, but you should try to look at it because it's great. So, bye. See you.
Thank you, Vasco. Thank you, and so good